Uh, Ladies and gentlemen, good afternoon. My name is Ben Mulwa, and I am the Governor Sonko's spokesperson. And first, I want to appreciate your taking time to be here with us this afternoon. We would wish to be brief and clarify a number of issues that have continued to emanate. Foremost, you are all aware that the governor has strongly indicated that he is willing and is actually indeed started the process of terminating the contractual engagement that the Nairobi City County government has with the national government through the deed of transfer that was signed on the 15th of February 2020. This is informed by consistent and blatant abuse of process, continuous abuse of laid down procedures, complete disregard of the rule of law, and to a large extent, it is actually coming off as an effort not only to embarrass the governor, but those who are behind it are determined to destroy the goodwill that the president and the governor demonstrated in coming up with the deed of transfer that was designed to enhance services delivery to the county government of Nairobi. Specifically, I wish to highlight a few things that need to be in the public domain for a good understanding as to why the governor feels it is necessary to terminate this deed of transfer as it is today. All of you will remember that on the 15th of March, 2020, the Kenya Revenue Authority, which under the deed of transfer was appointed as the principal revenue collection agent for the county government of Nairobi, went ahead and published in the daily newspapers 2 bank accounts purportedly for purposes of revenue collection. The Kenya Revenue Authority went ahead and opened 2 bank accounts in complete disregard of the provisions of the Public Finance Management Act and also in complete disregard of the County Government Act. The law is extremely clear that only the CEC finance of a county government can provide directions in terms of the opening or the closure of bank accounts. So that was the first illegality that we noted. Over and above that, the second, 2 days later on the 17th, KRA also went ahead to publish a notice indicating that they will be processing the payroll for the Nairobi City County government. KRA is a revenue collection agent, just like any other agent that the Nairobi City County government has had even before. So these are some of the things that are coming off as illegalities that we feel eventually will bring not only challenges to the county government, but also to the president in the future. All of you also remember that on the 23rd day of March 2020, the head of civil service wrote a letter purporting to appoint chief officers for the Nairobi City County government. We all know that the procedure for the appointment of chief officers is very well laid out in the County Governments Act. And there is no position called chief officer in the national government. So these are some of the issues that have continued to emanate to demonstrate that there might have been an ulterior motive behind the development of the deed of transfer. Third, you remember that on the 4th of April, 2020, the Public Service Commission put up an advertisement in the dailies purporting to transfer over 6,052 employees of the Nairobi City County government to the NMS. All of you will agree that there is a protocol that was signed between the County Public Service Board and the Public Service Commission to facilitate the transfer of the employees, especially on secondment. So our question is, why would the Public Service Commission take over the responsibility of the County Public Service Board, yet the employees are not currently assigned to the Public Service Commission? What that amounted to is an illegality that will eventually bring problems, especially to the 6,000 employees that are affected. And our view is that if these issues are not handled with the clarity that they require, ultimately we are going to have problems. Over and above that, all of you remember again, on the 2nd day of April this year, the Nairobi City County Assembly sat and discussed a budget. And as the governor made clear in his memorandum dated the 15th of April 2020, that particular budget was not authored procedurally. And he highlighted those inconsistencies with the law in the memorandum that he sent to the county assembly. However, with very interesting levels of impunity, the Speaker of the County Assembly, without even following the provisions of Sections 24 of the County Government Act, went ahead to reject the governor's memorandum and purported to return the original bill, which was not only fraudulent, but also allocated monies to functions that are still under the Nairobi County government. Eventually, the governor rejected that bill, but the Speaker, again with impunity, for the first time in the history of the Commonwealth countries, we have a case whereby a Speaker of an assembly has gone ahead to gazette a law contrary to all the provisions of existing laws. And this is a matter that is already, the county government is pursuing recourse in court, because we feel that it is important for this deed of transfer to be implemented procedurally. Let everybody follow the rule of law, and most importantly, let everybody be guided by the provision of Article 187(2)(b) of the Constitution that clearly states the responsibility of all the functions that have been transferred still rests with the Nairobi City County government. What we are witnessing here is a case of a few individuals within the national government who chose to hijack the process and abuse the goodwill that the president and the governor demonstrated, and have gone ahead to begin shenanigans that are not either guided by the law, and eventually when responsibility will be borne, like the case I have highlighted of the bank accounts. When the Auditor General ultimately flags the county government bank accounts of Nairobi County, believe you me, the NMS will never feature anywhere.